All right, let's bring in our guest this hour, criminal defense attorney Jeffrey Wolf. Jeffrey, great to see you, my friend. It's been a few weeks since we've done this rodeo, but always enjoy you on the program. Jeffrey, I feel like the defense is doing a good job of muddying the waters here and creating enough reasonable doubt, because I see a lot of it. I want to start here with the woman that was from the Nashville crime lab. She was talking about how she didn't detect any controlled substances in the glasses and the bottles that she tested, not in the liquids. She didn't test the food that was there, which I feel like was a missed opportunity by the investigators. But the glaring question is, where did this cocaine come from? That question is yet to be answered. We have seen no communications about going to get it. It's not in the things that she's tested. It just, all the cocaine just happens to be in Jade's system. That's a huge unanswered question by the prosecution right now.
Yeah, absolutely. I mean, we heard all the allegations that, she was saying it must have been in her drink at the time when this trial was getting ready to get started. And now they're saying they can't find it in any of the things that she had to drink or had to eat. And they didn't even test the food, right? So how did he drug her if it's not in any of the substances that she took in, if she didn't just take it herself like the defense is contending?
And Jeffrey, we just heard there, they're going back and forth with these communications. He's on the way to her place at 6:55. We'll round up to 7. Let's just assume maybe he lives 15, 20 minutes away. They do this paint and sip. They've got the dinner ready. The call to 911 comes in around 9:35, but she's on the phone with her friend with the whole, I think he put something in my drink at 9:25-ish. So you have 2 hours to get there, hang out a little bit, do this paint and sip, slip some cocaine in the drink, then call 911. And let's not forget, Jeffrey, he kind of calls 911 in this timely manner in like a 10-minute period. It doesn't seem like he has much time to conjure up a crime scene type situation. It's just, again, a lot of reasonable doubt here. What are you making from these communications in the timeline, I guess?
Yeah, I mean, typically what we see in stories where somebody is, setting the scene for law enforcement before they get there, when they do call, is we're having to see them clean up a little bit, right? We're having to see them clean up after a struggle that's ensued. Even if somebody hasn't been murdered in a brutal fashion, they're having to clean up something that's gone on. If they've drugged somebody, there's been some sort of struggle that's ensued, because that didn't have time to occur in this situation. And, certainly the perfect crimes exist, but man, it's a short amount of time to clean up after yourself to have nothing found later.
Absolutely, especially when she's on the phone with this friend who, not an eyewitness, but you're hearing things going on in the background. Stand by, my friend. Let's get back inside the courtroom for more testimony from this detective. Watching along with us this hour, criminal defense attorney Jeffrey Wolf. Jeffrey, this witness here going through a lot of minutia of the communications, but what I want to focus on is something that's pretty glaring, a glaring hole in the prosecution's case, is that the cause of death is literally undetermined. Meaning to me, anything is on the table here. It's a circumstantial case. The circumstantials aren't as strong as we've seen in other circumstantial cases that we've covered here at Court TV. I'm asking the question, what are the circumstances? Like, what are they? Just the fact that he was there? What do you make of this undetermined manner of death here, cause of death?
Yeah, I mean, it's the classic, if you have opportunity and you have motive, and quite frankly, if you are the loved one, the boyfriend or the girlfriend, the husband or the wife, you're going to be the prime suspect. And that is where he was at. He was the only one in the home with her, and she died under suspicious circumstances. Unknown circumstances are suspicious. They can't point to what caused her death, and he was there. He had opportunity. He had motive. They were a recently broken up and then gotten back together couple, and she had a baby that he didn't necessarily want. And he had a life that he had built. He had a promising future ahead of him as a coach that this could have brought down, because now he had a baby to be responsible for. And so it causes law enforcement to put the blinders on and move forward. And whether they're right or wrong, that's how investigations work.
Absolutely. You referenced it the way I was going to put it there, Jeffrey, put those blinders on. I felt like the state could be vulnerable to accusations of tunnel vision here because of those reasons that you just listed out. The idea he's the boyfriend, he was there, proximity, the motive of the unwanted baby. But, as this goes on, I feel like this is becoming as much a trial about the investigation as it is about the actual crime that occurred that Mr. Blaze Taylor is accused of here. But Jeffrey, let's talk about the defense's theory. I know you have all the expertise of criminal defense ideology, of course. What do you make of it, saying that she might have ingested this cocaine or substances, controlled substances, on her own? Because, I mean, that's all but saying this is a victim-blaming defense theory, and we know juries don't really take too kindly to victim blaming, but that might be all the defense has going for them.
The only people that hate victim blaming more than juries are court TV viewers, so I'm going to tread lightly here. But
you don't have to tell me twice about that.
But sometimes it's what you have to do as the defense because it's all you got. And there is a history of drug use for this young woman, but then we have a lot of people coming forward to say that she had cleaned up her act because she was pregnant. And it is a really, really tough sell to a jury that we have an expectant, happy, expectant mother who is going to continue those kinds of habits. But we see it all too often. We see people who don't clean up their act just because they're pregnant or just because they're expecting a baby on the male or female side. Mm-hmm. And we see kids born under the influence all the time in this country. And so I don't think it's as simple for the prosecution as saying, hey, she's pregnant. Who keeps using when they're pregnant? I'd like to see a little bit more than just her friends coming forward to show that she's not using. I'd like to see some medical records to prove it.
Some expert testimony. Great points made there, Jeffrey. My friends, stand by. All right, let's bring in criminal defense attorney Jeffrey Wolf to talk about this before we go in that courtroom to get this verdict. Jeffrey, 9.5 hours. I mean, I know this was a circumstantial case, but it felt like this was an insurmountable amount of circumstances that pointed directly at Mr. Hildabrand here. I'm shocked it took this long. What are you thinking?
Well, it's always nice to be put on the spot right before the verdict's read. We'll get an instant answer about whether I'm right or wrong. I think the jury is being thoughtful. And as you know from my last appearance, I don't like it when they're not. So regardless of what their verdict is, regardless of what their verdict is, I always like to see a jury take their time when someone's life is on the line. And so that is always encouraging. I know that it can be hard for people to wait. It can be hard for people in the courtroom, especially the lawyers, the defense, the prosecution, the victim family. Very hard to wait for a verdict, but jurors have a job to do. And it's very good to see them take it seriously because it is a serious job. And when they're spending 9.5 hours, what they're doing is they're actually going through the evidence. They're actually going through the jury instructions, reading the law, and making sure that they understand everything, that they're taking the proper votes, and they're giving everyone in the jury room a voice. That is what my understanding from talking to former jurors and friends of mine that have served on juries, that is what they're actually doing back there. What the verdict is almost impossible to know. Because I have seen juries come back very quickly and take a very long time and have the verdict go both ways. Now, this case itself, from what I've read of it and what I've seen of it, I would be shocked if it was a not guilty verdict. Absolutely shocked.
I would be floored. But again, we've seen stranger things have happened. Jeffrey, let's take a listen to some more of the state's closing arguments. They asked this jury 3 questions before they went back in there. Let's take a listen. Oh, actually, getting word from my producers. Let's go in live to the verdict here, Jeffrey. Wolf. And I'm shocked. In my avoidance of using any prohibited 4-letter words, I am gosh darn floored at this verdict here. Not guilty of first-degree murder, guilty of second-degree murder, and guilty of evidence tampering. I'm assuming the second degree, has no premeditation, obviously, maybe because they decided he was too drunk to premeditate a murder. But even then, is that even an excuse? I mean, we have a dead young woman here. And the thing about it, Jeffrey, I keep referencing this set of facts here regarding this case. When, after all this happened and he admitted to cleaning up and moving the body and all that, but when the police came to the apartment and they're searching the apartment and he's acting kind of funny, and then they get to the bedroom and they ask to look under the mattress topper, and he gets all weird, like, I don't know if you should look under there. I might have some embarrassing things like sex toys and what have you. And the police are like, okay, we'll just go get a warrant and come back. And when they come back, Jeffrey, it's a big, blood-soaked mattress that is soaked through the mattress to the floor. We got the guy at the store buying 96-gallon, tubs and all this different stuff. No premeditation. This is shocking to me.
Well, I think what we saw here is we saw a jury that took him at his word on the stand. And
Yeah.
that is a little surprising to me given his affect on the stand. But what he essentially said was he was intoxicated. He doesn't remember the argument. He doesn't remember the act. And if that's the case, it's really hard for the jury to be able to reconcile that this was premeditated. Clearly, there's a cover up. They took him at his word on that as well because he essentially confessed to that on the stand. But they don't have an answer as to how this all went down. They know there was a confrontation over the infidelity, and I think they believe that nobody but him could have committed the act based on the cover up and the opportunity. Again, opportunity, motive. There he is. And what I'll tell you is there's not a big difference in the sentencing in Alaska between first and second degree murder. The jury doesn't know that. They don't take sentencing into account, but this isn't going to buy him much, this verdict. But it is a surprising verdict. But it shows that back there for 9.5 hours, there was a very, very large argument going on in that jury room, and that there was a contingent that believed him, there was a contingent that didn't believe him, and the contingent that believed him won. And I'm guessing that there was nobody back there that didn't think he killed her at all. But certainly there was a compromise made, and the second degree murder was the compromise.
I mean, I feel like we have our answer as to why it took so long now. And to your point, Jeffrey, him on the stand, his affect on the stand, when the prosecution was crossing him up on cross-examination saying, okay, sir, you talked about all this guilt and remorse and shame and dishonesty and disrespect. Not once did you mention grief about your dead wife that you saw and witnessed and was bloodied up, according to him. And then they talked about how he, took a little break and, watched some pornography or something and drank some wine or whatever while his wife was over here deceased in the bedroom. He just because he's drunk, though, Jeffrey, I'm just wondering, I guess they came to their decision, is that an excuse? I mean, you could still mean to do something even though you're under the influence. It's just maybe you won't remember it, but maybe in the moment you meant to do it. I'm floored about it. And I guess, they concluded that the state failed to eliminate, the reasonable doubt surrounding the suicide and everything. Clearly he's guilty of evidence tampering, but I'm just surprised it took him at his word here.
Well, it's not an excuse and it's not a defense, right? They didn't find him not guilty of the whole thing. It's not
right.
way that you get found not guilty of the whole thing. So frame your reaction to it a little bit differently, and the viewers should do the same. They're not saying it's a defense to the crime. They're changing the mens rea, what was going through his head and the premeditation, whether he planned this out and intended for it to happen that night, and whether he went into that night intending to murder his wife. And that's what the jury is saying. And the jury's verdict is sacrosanct. It is not anyone's job to ever sit and judge a jury's verdict for better or for worse. And at the end of the day, this jury was not convinced that he planned this out, that he intended for this to happen that night. It's more of a crime of passion verdict. And alcohol is not a defense to any crime. Voluntary intoxication is not a defense to any crime. But it's not about whether it was a defense to this murder. That's not what their verdict says. What their verdict says was that the intoxication to them meant that he didn't plan it, that the intoxication may have created a state of mind for him that otherwise wouldn't have been there.
See, this is why you're the expert, Jeffrey. This is why we bring you on. We love the expertise. I'm just sitting up here at the desk as the TV boy. Jeffrey, let's talk about sentencing here. October 23rd. What do you think the defense will be prepping going forward? I mean, we're some months away from that.
Yeah, I mean, this is a former soldier, right? So I think they're going to try and tell the judge that this does not define his entire life, that this was a moment in time. That is a defense lawyer's job, even in the most heinous of circumstances. And so what they need to do is they need to get a cast of characters from his life to paint the picture of who Zarrius is and who he has been the rest of his life, and how this ended up happening in his life, and how he ended up doing this, and what he has contributed to the world outside of what he took. That is their job.
Mm-hmm.
And when they say there are a lot of people that are going to want to talk, what they mean is that he has meant a lot to a lot of people before he became what he now is to this young woman's family, and what people now see him as today is that he meant something to a lot of people before this. And that is their job, is to present that to the judge and let the judge know that he's not unredeemable.
Absolutely. I guess as bad and horrendous as this moment is, I guess not trying to define him fully in this one particular moment, but just as they said, a lot of people are going to want to talk on his behalf. I'm guaranteed there's going to be a lot that want to talk on Sarai's behalf as well. Jeffrey, stand by, my friend. After this, all right, still watching along with us, criminal defense attorney Jeffrey Wolf. Jeffrey, they're walking through a lot of phone communications and Snapchat stories and what have you here. Kind of getting lost upon me. Where do you think they're kind of going with some of this? What are they trying to do here?
Well, where they were at just now is he's starting to try and establish his own little theory about how well she was taking care of herself during this pregnancy. Went through some doctor's appointments, went through the mood she was in during the doctor's appointments, going through the mocktail recipes that she's getting off of Pinterest, going to the gym, things like that. This is going towards, the fact that they don't think she was on any drugs or drinking during the pregnancy. It's not necessarily proof that she wasn't. It's what the public face she was putting forward. I think we all know that the face that somebody puts on social media isn't necessarily who they actually are. And it's a nice little show by this detective, but it's not necessarily the truth of who somebody is. And, I think the prosecution might want to be careful that they don't step in it.
Absolutely. And one thing about the defense too here, Jeffrey, in this case is that they keep returning to the fact that, these friends and family members, went to this apartment, entered the apartment following this incident. I understand that's a critical issue for the defense here because essentially that's kind of like a compromised crime scene where they're moving things and removing things. Of course, at the time, it wasn't a crime scene per se, but the thing about it is, once investigators got around to it, the question remains whether investigators could have gotten, an accurate analysis of this crime scene given how many people have come and gone.
Right, absolutely. And what did they not know to look for when it wasn't a crime scene any longer? What could the defense have, found if they had returned to the scene that maybe the friends and family knows are there, that the police didn't know was there? What could they have been removing? They will say what they removed, but you don't know what they took. And, you want to secure a potential murder scene for, longer than just the night in question. It's odd that people were allowed to go in and that people certainly were allowed to take things and move things. That's not appropriate.
Yeah, that's the thing about it, because to me, it's like how much reasonable doubt could you create by showing investigators missed, potentially crucial evidence? I mean, they talked about the removal of this comforter containing vomit by her friend, which could create, a genuine evidentiary problem for these prosecutors as they move forward. I mentioned before, I feel like some parts of this is a trial as much about the investigation as it is about the crime itself, or the alleged crime, I should say.
Yeah, absolutely. When we're talking about vomit that could contain biological samples of what was in her system at the time that all of this went down, we're talking about cocaine. We're talking about something that goes through your system very quickly. And so, all biological samples matter when you're talking about cocaine. And quite frankly, you have no idea what somebody took out. You know what they're telling us that they took, but we have no idea what they actually took.
Absolutely. Jeffrey Wolf, thank you so much for joining us tonight, my friend. Your expertise, always welcomed. We'll do it again soon. Folks, stand by. We're going to keep it right here.